Great. This is case number 2024-000-202-MZ. The Detroit Public Schools Community District and the School District of the City of Detroit against the Michigan Department of Treasury and Rachel Eubanks in her official capacity as the State Treasurer of the State of Michigan. This case is very early in its development, but we already have a couple of significant motions filed. I'm going to take up one today and defer on the other one. The case began with the filing of a verified complaint for declaratory and injunctive relief on December 20th of 2024. And along with that filing of the complaint came the plaintiff's emergency motion for temporary restraining order and preliminary injunction. That's the motion that I'm focusing on today. As I understand it, a decision must be rendered before February 10th, no matter what. And I'm going to explain why that date's significant, but you're going to get it well before February 10th. I'll note before I go any further that although the request is a motion for a temporary restraining order and a preliminary injunction, the time has really passed and the situation is no longer appropriate for the entry of a temporary restraining order. What we're talking about today is merely whether the court should grant a preliminary injunction or not. The other motion that was filed is the defendant's January 10th, 2025 motion for summary disposition in lieu of an answer. Now, I don't intend to decide that motion based upon what's said at today's hearing, although I recognize that the arguments in the motion for summary disposition in the brief are incorporated into the analysis of the propriety of a preliminary injunction. So, of course, I've read the motion in the brief, but I don't want to decide that one yet today. There are several other things I don't want to talk about today because I just don't think I'm going to be persuaded today, and they don't really matter for the analysis of what we're doing anyway. The summary disposition motion seeks relief under MCR 2.116C8, and at some point we'll have to have a talk about what I can all consider for C8, but there are a fair number of attachments to the complaint, and at least I'd like to consider those when I get to the C8 question. Under MCR 2.113, I can consider attachments to a complaint, although usually it's a contract or something like that. Here, the exchange of letters and everything else that helps set up the argument is well worth considering. That's for another day. Next, to the extent that the defendants are arguing ripeness, I'm not persuaded today by that argument. I'm a stickler on the prudential doctrines of standing, mootness, and ripeness, but it's a request for declaratory relief, and I tend to think that we don't have a ripeness problem here. There's also a question about whether the correct defendants have been named, and I understand that that argument may have some merit to it, although I think the reply brief does a nice job of handling the argument that for all practical purposes, neither the Michigan Department of Treasury nor Ms. Eubanks has any ability to do anything other than follow the law. So I think you can fairly assume that the analysis of the preliminary injunction request is not going to turn on whether we have the right defendants or not. That will matter more when we get to summary disposition. So I'd really like to get to the merits because we have to consider the likelihood of success on the merits as the first of four factors in analyzing the propriety of a preliminary injunction. On the other side, in the reply brief, the plaintiffs first argue that the response to the motion for preliminary injunction was untimely. I am not moved by that at all. This request, which is substantial, was filed right before Christmas. The response came in on January 10th, and there was plenty of time for a reply brief, so I'm satisfied that it's before me as a contested motion. In addition, I'm not concerned about the page limit. First of all, in my many years running the business docket in Kent County, I encountered lots of overlength briefs. If anybody ever asked for permission to file an overlength brief, I always granted it. And here, the mere fact that the argument split up into, I think, 15 pages for summary disposition and 7 pages or something like that for the preliminary injunction causes me no concern whatsoever. So what I'd like to do then is get right to the merits. And I've done enough analysis of preliminary injunction requests that I think if I ever get dementia, the last thing I'll remember are the 4 elements for preliminary injunctions. It truly is seared into my brain. So we're talking about the likelihood of success on the merits. We're talking about the likelihood of irreparable harm to the plaintiff if an injunction is not granted. And that is essential. Absent irreparable harm, there's really no basis at all for granting an injunction under Michigan law. Then the third factor is balancing of the harms. And the fourth factor is the public interest. So I'd like you to focus on those 4 aspects of what we have to decide here today. Having said that, let me turn to the merits and tell you what I know, because I think both my senior law clerk and I have spent a lot of time reading and talking about this case. And this is what I think I know. So let me see if I can walk through this a little bit. First of all, I'll say that the complaint in this case is truly excellent. It really makes it easy to follow in trying to figure out what happened here. And I think my understanding of the case is much better than it ordinarily would be because the complaint is so good. If you go back to 2016, the Detroit Public Schools, which is its own entity, had more than $3 billion in outstanding debt and was in a crisis situation. So in June of 2016, the legislature got involved and the Detroit Public Schools were restructured to exist as a separate taxing entity, and there was a new district created. The new district, for all practical purposes, is the operational functioning Detroit Public School District, but it has a different name. And the DPS itself has remained as effectively a shell that owes a lot of money and is trying to navigate those debt obligations to the best of its ability. But once it pays off the last of its debts, as I understand it, ceases to exist and it just evaporates. And the new district just continues to run the educational system in the city of Detroit. Now, in conjunction with the restructuring of public education in Detroit, there was a $150 million emergency loan extended. And the emergency loan is one of the central focuses of what we're doing today. As I understand it, there have been payments made against that emergency loan obligation of $150 million. And thankfully, property values are going up in the city of Detroit, money's coming in. And as a result of that, the DPS is now within striking distance of paying off that emergency loan. And what this case really asks is what happens next? So if you go back and you look at the obligations that are owed by the DPS, at least as far as I can tell, there are 3 different components. There's a $1.3 billion obligation on outstanding bonds. There's a revolving fund debt of about $350 million. And then there's this $150 million emergency loan. And the emergency loan, at least for the time being, is being paid off by revenue from an operating tax. The operating tax was approved by the voters of the city of Detroit. And as I understand it, the authorization to collect this operating tax without considering any of the events on the ground extends for some significant period of time. In other words, the right to collect the operating tax doesn't expire in 2025. It doesn't expire, I think, for years. Along the way, there's also a debt millage, and the debt millage is being used to service the obligations on the revolving fund debt and the outstanding bonds. So the bulk of the financial obligation will remain even after this $150 million emergency loan gets paid off. But the real question before us is, once that $150 million emergency loan gets paid off through money generated by the operating tax, does the operating tax go away, or can the new district seek its own operating tax? Because I think an operating tax by both the DPS and the new entity are mutually exclusive. They can't both seek an operating tax. They can't go to the voters and double dip. But what the plaintiffs want to do is continue to receive the revenue from the operating tax after the $150 million emergency loan is paid off and apply that money to pay off these other obligations on the revolving fund debt and the outstanding bonds. If I'm getting something wrong along the way, you'll get your chance to correct me, but I think that's the basic situation here today. Now, if you look at the parties' positions, it doesn't make a lot of sense unless you understand how public education is being funded now in the city of Detroit. There are foundation grant funds that make up a big portion of it. I think there's still the $75 million or so a year from the tobacco settlement. And then to the extent there's a shortfall beyond that, I think, although I don't know, that the general fund has to be used to cover whatever excess obligations there are. Now, if you look at the way that the various components of the debt owed by the Detroit Public Schools are structured, you'll see that it's going to take years, even in the best of circumstances, to pay off the revolving fund debt and the outstanding bond obligations. And so I think that the plaintiffs simply want the court to enter some sort of an order, however it might be styled, that would say that the DPS, not the new entity, can continue to collect money under the operating tax and then apply it not to the $150 million emergency loan balance, but rather to try to clean up the revolving fund debt and the outstanding bond obligations. Now, the Treasury Department disagrees with that analysis, essentially taking the position that once that $150 million loan, the emergency loan, is repaid, that will, in essence, end the DPS's right to collect the operating tax. And as a matter of fact, if you look at the complaint, there's a letter from October 16, 2024, that's beautifully written by the Treasury Department that explains exactly what the Treasury Department's position is in this case. And in response to some questions, we get a very key exchange, Treasury asking itself a question that it thought the plaintiffs were asking and then answering it. It's question number 2. If the answer to question number 1 is no, and all the operating debt of the old district is fully repaid, is the old district authorized to levy an operating millage? Treasury says no, and it explains the following. While section 12B of the school code, and I'll note parenthetically, that's MCL 380.12 small b, does not provide a direct answer to this question, and I certainly would agree that the statute doesn't answer the question. The parameters of historical school elector approval, as well as the legislative history and expectations of the state, the old district and the new district at the time the new district was established, all suggest that once the operating obligations are paid, the old district is no longer authorized to levy an operating tax. And I think that's the crux of the dispute. But in terms of irreparable harm, it's worth looking at the question and answer number 3 as well. If the old district is no longer authorized to levy an operating millage after the repayment of its legacy operating debt, is the new district authorized to seek voter approval for an operating levy to support its operations and foundation allowance? Here, the answer is yes. Once the old district has paid the legacy operating debt and is no longer authorized to levy an operating tax, Section 386 of the school code would no longer prevent the new district from levying an operating tax. And I think that's where I'm struggling a bit with the plaintiff's claim of a high risk of irreparable harm, because I get the fact that once the $150 million emergency loan gets paid off, DPS cannot collect the operating tax any longer. But in essence, that opens the door for the new district to try to collect an operating tax. Now, of course, that requires going to the voters, and the voters would have to approve it. And I think in order to get on the ballot in May, which would be the earliest possible time, something has to be submitted by February 10th, hence the need for speed here, so that we can at least put the new district in a position to go to the voters. Now, the really tricky problem, I guess, is if I deny injunctive relief, and then your new client goes to the voters and the voters say no, then what happens? I mean, that's a real mess. Obviously, if the voters say yes, there might be some period where you wouldn't have revenue from any operating tax, either for DPS or the new school, the new district. But that's just a matter of months, I think. And the other thing you need to know about this is there is this difficult question about who makes the decision that the operating tax collected by DPS has to go away when the $150 million emergency loan gets paid. The defendants say, not us. We're just following the law. We don't have anything to do with this except what we're required to do. The legislature appropriates and we just do what they tell us to do. The plaintiffs say that's hogwash. It really is incumbent upon Ms. Eubanks as the treasurer to certify that the $150 million loan has been paid in full. And once she does that, the consequence is that there's a directive from somebody, whether it's the Treasury or the Department of Education or whoever the case may be, but somebody says, okay, DPS, you have to stop collecting your operating tax. And if you try to do that, we're going to cut into your foundation allowance. Now, that's a lot that I said at the beginning of this, and I didn't mean to drone on, but I think that sets up the discussion very nicely. If I've said something wrong, please correct me, because we're going to write an opinion and it's going to be comprehensive and I want it to be right in all respects. So start by telling me what I did wrong. And then after that, Mr. Eldridge, I'll be glad to hear anything you want to say, but please, 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 focus on the four factors. Yeah, please focus on the four factors. And your greatest challenge, I think, is to convince me that there's a likelihood of irreparable harm. Because among other things, they say you can just not pay the $150 million loan off right away. You've got 18 months or something like that.
Sure. Okay. Thank you. May it please the court, Your Honor. Scott Eldridge again on behalf of plaintiffs. Two housekeeping matters, if I may address before I dig into the elements. Just a reminder, you mentioned other filings that had come in. We also filed a motion for summary disposition, a cross motion for summary disposition on Friday, the same day that we responded to their motion.
For some reason, I didn't pick that up, but don't worry about it. You'll get your chance.
It effectively says all the same things. It's a C10 motion.
Oh, okay. Okay.
Asking for summary disposition in our favor. In response to their motion, their C8 motion, we of course cited 2.116 subparens I.
I2, right?
Yes.
Oh, yeah.
Yes.
That's fine. And the only reason I mentioned their summary disposition motion is the arguments are specifically incorporated in the preliminary injunction response.
Yes.
But my concern today is not with granting summary disposition to anybody.
I understand.
We've got time to do that.
I understand. I just wanted to make sure that wasn't missed.
No, I promise it won't be. When I get around to the summary disposition motion, we'll hear all of them, including yours.
Thank you, Your Honor. Also, with the second housekeeping item is just want to make sure the court is aware that we filed a corrected exhibit mid last week, replacing our original exhibit 4 with what we were supposed to file, which is an October 8th memo from Treasury.
Yep.
Addressing the issues in a bit more detail.
Right. What you
Very
attach-
similar to the October 16th letter you referenced earlier. It's similar, but it's just lengthier. I just want to make sure the court was aware that we had submitted that.
Yeah, and I'll find that. I was a little bit puzzled because your original Exhibit 4 appears to be a Miller Canfield document.
That's right. It was, and that was just submitted inadvertently. We corrected it last week.
That's fine. I'll replace that. Thank you very much.
Yes.
Yeah, I was a little puzzled because I had what I had in my hands this morning. I didn't go back and try to figure out what else had come in.
Fair. Okay, thank you, Your Honor. I don't think there's anything glaring that I need to correct from your
So I got it basically right. I may not have gotten it
I think you did. And ultimately, we are here to decide, can DPS continue levying its operating millage once it repays this emergency loan? The emergency loan repayment schedule was set.
Can you stop for just one second? Because I want to understand, assuming that everything stays the same and you can continue to collect that operating tax, what's the life of it?
Oh, the life of the operating tax itself?
Is it
Currently,
years?
it's set to expire in 2033.
Okay, so in other words, you'd have a revenue stream for 8 more years if I go your way.
Correct, and which will, if you go our way, we'll be able to apply against the other remaining outstanding debt and avoid hundreds of $millions in unnecessary interest payments, which of course, I'll get to in a minute as part of the irreparable harm, we can never recoup. This is not a case for money damages. We're not asking for money damages.
Right. I mean, right. You've asked for declaratory and injunctive relief, and by definition, that's not money damages. And I suspect the reason you're not asking for money damages is this would actually have to be money appropriated.
Correct.
And I can't direct the legislature to appropriate money.
Exactly right. But you can prevent the harm through an injunction.
I understand.
And it's irreparable harm.
Right.
It is irreparable because we have no adequate remedy at law in that regard. But I want to get to the statutory examination here, because that's what's most critical to you deciding whether we can show a likelihood of success on the merits. I do want to correct one thing that you said,
Sure.
Your Honor. I'm not going to get this verbatim, but you said something along the lines of Section 12B of the revised school code does not answer the question directly. We disagree.
Oh, I was reading what they said.
Oh, gotcha. Okay.
Yeah.
Okay.
I take no position on that. It may very well answer it, and I'll say that in my opinion, but so far I've taken no position on that. They said that in their letter.
Yeah. Okay. Fair. Yes, they did. We don't think you have to look any farther than 12B to answer the question that's in front of you.
Okay, so walk me through the statute.
Yeah. So 12B of the revised school code, which is MCL 380.12B, as in boy, is the statute that governs what happens next. What can DPS do and what must it do with this operating millage once the emergency loan is paid off? And I want to direct your attention to subparents 3 sub B.
I had a feeling you were going there, so I have it marked and everything. Go ahead.
So 3, towards the bottom part of that long paragraph that starts with subparents 3 is the most important, where the most important language starts. And it starts, until that date, the transition manager, which is of course now in the hands of, the power of that transition manager is now in the hands of the school board, right? Shall perform the functions and satisfy the responsibilities of the school board and superintendent of schools of the qualifying school district, that's of course DPS, relating to the payment of debt and the dissolution of the qualifying school district, including but not limited to all of the following, end quote. I'm going to pause there for a minute and circle back to the most important word, perhaps in two most important words, perhaps in that passage I just read, which is shall perform, or shall. We know that's mandatory. And then the word debt. This speaks to the repayment of debt. It does not speak to the repayment of operating obligations. It does not speak to the repayment of operating debt, whatever that phrase means. It doesn't refer to anything other than debt. Debt is a defined term in this same statute. And I'll get to that in a second, but I want to finish with my recitation of the important language in 3B. So I read the last sentence of subparens 3, which then takes us down to subparens B as in boy, as the operating or operative provision, which says, quote, doing all other things relative to the repayment of outstanding debt of the qualifying school district required by law and by the terms of the debt, including but not limited to, and I'm going to skip down to the part about levying taxes, quote, levying or seeking voter approval for a renewal of a school operating tax under section 1211, end quote. That is the most important language. And the reason you don't have to look anywhere outside of 12B to answer this question is because it refers to the repayment of debt and only the repayment of debt. Debt, as I mentioned, is a defined term farther down in the statute in section subparens 15, subparens A. And debt is defined very broadly. I'm not sure that we could all imagine a different set of language that the legislature could use to make clear and unmistakable their intent to define debt as broadly as humanly possible. First, it says debt means, quote, that term as defined in section 103 of the revised Municipal Finance Act, end quote. I'm going to pause there. If you look to that definition, Your Honor, it in and of itself is exceptionally broad without any real limitation. And if you bear with me, I will find the precise citation.
And just to be clear, that's MCL 141.2103.
Correct. And it
says
defines,
so right here.
yes, yeah, it does. Thank you. It defines debt, for the record, as, quote, means all borrowed money, loans, and other indebtedness, including principal and interest, evidenced by bonds, obligations, refunding obligations, notes, contracts, securities, refunding securities, municipal securities, or certificates of indebtedness that are lawfully issued or assumed in whole or in part by a municipality or will be evidenced by a judgment or decree against the municipality. End quote. That is, in shorthand, defining all monies owed. It's exceptionally broad.
Right. And if there were any doubt about that, the statutory definition takes everything you just said and adds a whole bunch of other categories to it, including a catch-all at the end, quote, any other monetary obligations of the qualifying school district. So in case you wondered what debt doesn't include, the answer is nothing.
Correct. You read my mind, Your Honor. That's where I was going to go next. That subparens mini Roman numeral 6 under the definition of debt in the revised school code of 12B has this exceptionally broad catch-all, which would obviously include a revolving fund, which is money owed, any obligation owed, and the outstanding bonds, any obligation owed. Again, the legislature could not have been more clear about this. Defendants want to redirect you to other provisions in other provisions of this very statute and to 1211. I want to talk about why you don't need to consider those and why they're wrong about their focus on the definition of operating obligations in subparens 15B of the revised school code, section 12B. There's definitely a definition of operating obligation, right? It's there for us to read. We can see it. I don't need to read it into the record. The legislature felt compelled to define it, but they assigned kind of a reason for it, and it simply triggers a notice obligation on behalf of the state treasurer to notify the new district once those operating obligations as defined there are paid off, nothing more. It's simply a notice obligation. That's what the legislature said. That's what the legislature intended. That limited task of notification happening if operating obligations are paid off. Again, noticeably absent from section 3B, 3 and 3B, is any reference to the phrase operating obligations. The payment of operating obligations does not relate to DPS's continued obligation to then continue to levy that operating tax
Right.
under 12,
I
under
take your, I
1211.
take your point, because if you look at 3B, it begins with doing all other things relative to the repayment of outstanding debt. And if they'd meant to limit it in some way, they would have instead said, doing all other things relative to the repayment of operating obligations.
Exactly.
Right. I mean, they defined the two terms one after the other. They chose debt rather than operating obligation.
That's exactly right. That's exactly right. And they didn't leave operating obligations just kind of there alone on an island. It tied it to this notice obligation, which they felt, for whatever reason, important, but certainly didn't tie it to DPS's ability to continue levying. Not only ability, I actually misspoke. They're required by this statute to continue levying the operating tax. This is not a choice that DPS has. The statute says they are required to continue levying this operating tax to pay off all debt.
Right. And presumably, if the legislature were concerned about rescuing these flailing districts, what they would want is to take every revenue stream available and direct it to paying all the debt, whatever may be the constituent parts of it.
Correct. Correct. Debt means debt. And it's not confusing. It's not, and the legislature, again, did not mince words. It said debt, and we're going to tell you all the different ways you can define debt as broadly as humanly possible because we want to encompass all of it.
Okay, now I understand that argument perfectly, but stop for a minute and tie this into irreparable harm, because I think we can all agree, and I'm not saying that it's your preferred approach, but we can all agree that if DPS stops collecting the operating tax, that clears the playing field for the new district to seek authorization to collect an operating tax. Now, I know there are hurdles along the way. It has to go on the ballot. The voters have to approve it and all that. But if there is, in fact, a cutoff, whether it's wrongly or rightly imposed, once the $150 million emergency loan is paid off, that prevents DPS from going forward and continuing to collect the operating tax, how long would it take, or how much money would be foregone if your client, the new district, had to go to the voters, get their approval, and then essentially get that new operating tax up and running?
So the new district, under the defendant's theory, would go to the voters and ask for basically it's not really a replacement operating tax. It's just a new district operating tax that cannot be used to pay off DPS's remaining debt.
I thought you were going to say that because I wondered about that.
Cannot be used.
In other words, if the new district is collecting money through an operating tax, it's not allowed to take that money and give it to DPS.
No.
In essence, that would be contrary to what the voters expected when they voted for the operating tax. The operating tax presented to the voters would be something they would expect would fund the new district.
Correct.
Not pay the legacy costs of the old district.
And remember, defendants are also taking the position that operating tax can't be used to pay off that debt anyways, even if the new district could use it to pay the revolving fund and the bond debt.
I see. So in essence, then, you're hamstrung more than I first understood. And by you, I mean your clients collectively.
Correct.
Because DPS loses a revenue stream. And even if the new district turns around, goes to the voters and gets an equal amount of money through a revenue stream for an operating tax, it can't go to retire the legacy debt.
Correct.
Okay.
Correct. So what's left is the 13 mills on the debt millage that you referenced in your opening remarks back at DPS to pay off very slowly, much more slowly than they otherwise would be able to with the operating tax, that legacy debt, as you referred to it, the bonds and the revolving fund debt, to the tune of incurring an additional $320 some odd million in interest.
Right.
Because it's going to take now that much longer to pay that off if they can't use the operating tax as we say they can. So,
Play that out for the fourth factor, then the public interest. Who pays that extra money?
well,
The 320 some million dollars you just mentioned.
it's
Somebody pays it up, but
it comes through the 13 mills that's being
okay, so
yeah,
so if
local
you talk
13
about the
mills.
public interest, then it's the taxpayers of the city of Detroit
Yeah, of
who have
course.
to foot the bill for
Yeah,
that.
of course. Absolutely. And that's, again, that's not money that we can recoup if we prevail without an injunction. If we prevail at the end of this, whenever you rule on the merits at the end and there's a final order, if that's 6 months from now, whatever interest we pay, and even if you agree with us, that money's gone.
Okay, so just to be clear about this then, the lack of an injunction translates to about a $320 million additional obligation imposed on the taxpayers of the city of Detroit.
Denying it does.
Right.
Yeah, denying the injunction.
Oh,
does.
I'm sorry. If I said granting,
Yeah.
yeah, I meant denying it. Right.
Denying the injunction
Right,
would,
right.
yes. And
I'm
again, Treasury is not going to cut us a check at the end of the day to make that money up. They don't have the authority to do that.
Right.
They'd have to go get an appropriation, which of course, nobody in this room has any control over.
Well, right, and they're a stranger to that transaction anyway, because that's really a transaction where the voters of the taxpayers of Detroit have to pay it, you collect it, and they have no relationship to that collection process.
Correct. And you alluded to this earlier, Your Honor, but I just don't want to lose sight of it. And that is, it's always possible that the voters don't approve the new district.
Right, right. And believe me,
operating
that clearly would be catastrophic, but not as catastrophic as I thought, because even if you get voter approval for it, that money's got to be plowed into the new district.
Yes, it does. It does.
So it doesn't have anything to do with satisfying the legacy obligations anymore.
So that's why we say this money isn't about, I'm sorry, this case isn't about money damages. It's about money, but we're not seeking damages because I'm guessing Treasury agrees with us that they can't just cut us a check if we prevail at the end of this without a preliminary injunction.
Right.
And so that's irreparable harm, and we're left without a adequate remedy at law.
I understand it much better.
So what I haven't discussed, and I want to, because I know counsel on the other side is going to address it, and that is, they want to steer you not only to this definition of operating obligation that we talked about, which we contend is irrelevant to the inquiry, but they're also going to try and steer you back to section 1211, which is what is the mechanism or the vehicle by which the operating tax can exist in the first place, right? That's the section 1211 of the revised school code. It has this definition of school operating purposes that defendants say does not include this sort of legacy debt either. Can't use it to pay things other than what are enumerated in the statute. We think they're wrong about that. So even if you are convinced that we have to look at 1211 in the definition of school operating purposes, again, we don't think you do, because we think you can answer the question just by focusing on 12B in and of itself. But even if you look at school operating purposes in that definition, as they encourage you to do, we still think it's broad enough to encompass this. And encompass, when I say this, I mean the bond, the outstanding
Right,
bond.
servicing the legacy debt.
Correct,
Right,
correct.
with the continuation of the operating.
And there's a couple of reasons. We put it in our briefing, Your Honor, and it has to do with the language that's used in that definition. The definition starts out by saying school operating purposes includes, and then it lists a handful of things. It includes, according to the case law that we cited to you, has been interpreted as being an enlargement term as opposed to a limiting term by Michigan courts. But more importantly, perhaps, is after that definition of school operating purposes, we admit it doesn't expressly say the revolving fund loan or the the bond debt necessarily. But after that definition, there's another section of express exclusions. And there's a handful, maybe 4 or 5 exclusions from the definition of school operating purposes. If the definition wasn't meant to be inclusive and expansive, there would have been no need for the legislature to identify express exclusions.
Right.
And noticeably absent from those lists of exclusions are the revolving fund debt or the capital investment bonds that are at issue. So we think we still win under their analysis, even if you look to 1211 in the definition of school operating purposes.
Let me ask you a different question, because one of the principal understandings of injunctive relief is it maintains the status quo. Your position is, I think, that this maintains the status quo. Their position is you're fundamentally altering the status quo, which always makes me nervous whenever I'm asked to grant injunctive relief. So help me understand why all you're trying to do is maintain the status quo here.
You read my mind again,
Okay.
Your Honor, because I jotted down the things you wanted us to talk about, and then I added a number 5, which was status quo. And we may not have said it as directly in our briefing, although we did reference the basis for it. The status quo is the Inkster matter. Inkster schools in 2022 went through a very similar situation. In Treasury, it's an exhibit. I think it's exhibit 7.
I read all the Inkster stuff.
Right. Okay. So yes, it was a slightly different statute, but the language in section 12, which was at issue in the Inkster matter, and in the language in section 12B that's at issue here, are virtually identical in all the most material ways. It was debt. It uses the word debt and debt only, and it defines it pretty close to the same way. It's not as long of a definition, but it incorporates that really broad statute that I started talking about. In Treasury had no problem saying once Inkster pays off its emergency loan, it's required to continue levying its operating tax under 1211 to pay off its revolving fund debt. The very same issue. They've done an about face for some reason that we don't understand and we think is wrong. And they've done that about face here, which we think upends the status quo. That Inkster was the status quo, and everybody was operating under the assumption that that's how this goes. And then that this is what will happen until we raise the question, what are we going to do when we got the October 8th and October 16th letters from them drawing their line in the sand saying, no, you're not going to do this. And we're going to actually withhold trust fund money and foundation allowance money effectively, which is made up of trust fund money. And if that gets depleted, they're required to dip into the general fund.
Right. Yep.
And of course, Treasury controls all of that by statute. Nobody else controls that. That's Treasury.
Well, yes and no. I mean, the legislature appropriates. So if there are general fund dollars available.
The Trust Fund Act specifically doesn't mention appropriation.
Okay, so just to be clear about that, your position under the Trust Fund Act is that the treasurer has the ability to access general fund dollars
It
to
requires,
satisfy this obligation.
it instructs them to.
Okay.
It absolutely instructs them to. I can walk you through the statute if you'd like me to, but
No. That's fine. But come back to the status quo argument for just a moment, because
I'm sorry, Your Honor, the what?
come back to the status quo argument for just a moment, because I certainly understood why you find the Inkster example so persuasive, but it struck me as odd because you can't really rely on it for governmental estoppel. I mean, governmental estoppel almost requires an actual policy. And I think what you're telling me today is I shouldn't think about Inkster as a governmental estoppel problem for them. I should instead think of it as a status quo issue.
Yeah, I think that's right. I don't think governmental estoppel appears anywhere in our complaint or anywhere in our briefing.
No. I'm not accusing you of that. I'm just trying to
I
understand.
I think that's right, Your Honor. It is the status quo. That's how everyone's been operating. We've been operating under the idea that we'll repay this and we'll repay the legacy debt and we'll be done with it. And then, like the statute says, right? I mean, the statute is the status quo to a large degree. The statute tells us, the statute governed Inkster And the statute continues to govern until we get to October 8th, and all of a sudden they've taken a different position.
And just to be clear about that, I think you concede that so long as DPS is collecting the operating tax, the new entity cannot
Yeah, that's
seek an operating tax.
That's right. That's in section
Yep,
386.
right. They're mutually
of the stat-
exclusive.
Of the
Either-
statute. It says you cannot do it, right? So once this emergency loan though gets paid off, of course, in 12B, the statute requires us to continue, DPS to continue levying the operating tax.
Doesn't it seem anomalous, though, to use revenue from an operating tax not to fund school operations, but rather to kill off legacy debt?
Well, I mean, paying off legacy debt is school operation. I mean, that is an operation of the school. But the other thing that's important is that those bonds, the legacy debt, the bonds and the revolving fund are all issued per statute, 1351 and 1351A, that are all backed by the full faith and credit and pledged on the general funds
Yep.
of
I
the
got
school district. So it would
I
be
got it.
weird if we can't use general funds, you know, a bond, you can't use operating tax to pay off debt that is, you know, secured through and backed by the general funds and full faith and credit of the
I
of the
got
school
it,
district.
but, and it may be a bit of a legal fiction, but I mean, you really have two separate entities here. You have DPS and then you have the successor, right? And the successor is the one that's providing education to the children
Yeah.
of Detroit, not DPS. DPS doesn't do anything like that anymore.
Correct. But, you know, in the legislature's infinite wisdom, we are here talking about a statute that is plain as day in 12B about what happens next. I wish I could explain the legislature's thinking in 2016. I don't know that I'm equipped to do that. But here we are, and the statute says what the statute says.
Okay.
Any other questions for me?
No, you've
Thank you.
done great answering my questions. Thank
Thank
you
you.
very much, Mr. Eldridge. Mr. Thompson, come on up. I have a feeling you don't agree with everything Mr. Eldridge said, but let's start with whether you agree with everything I said.
Well, good morning again, Your Honor, and just for the record, may it please the court, Assistant Attorney General David Thompson here on behalf of the defendants. Your Honor, I appreciate the opportunity to come in and hash these issues out with you. Thank you for having this hearing.
I learned so much from oral argument. I will always have oral argument. It's so
Yes.
helpful.
And Your Honor, this is the second time I've been before you and the first time you were remarkably inquisitive, and I noticed the same thing here today. And our clients always appreciate that because these are complicated matters.
Right.
And we do, as a general proposition, we perceive not only DPS, but all the school districts around the state to be in partnership with the state, right? We are in partnership with local units of government, and those include school districts, and the relationship with both the old district and the new district is an important one that we want to make sure that we maintain.
Right. And I think that that's not lost on me when we talk about the public interest here, because I think you identified nearly 1,000 school districts, and to some degree, it can be viewed as a zero-sum game. Every dollar that goes to DPS or the new version of DPS is a dollar that doesn't go to somebody else.
That's correct, Your Honor. But we try to get it right. And part of getting it right is having this type of exchange with you and your questions. And so for that reason, we're deeply grateful for your
Sure. Oh, yeah.
inquisitiveness. Based on the discussion, it sounds like the first and second elements are kind of one and the same in a way, that this question of irreparable harm and the likelihood of success. But I want to talk about irreparable harm first. I guess I'm starting with the end of the conversation and working my way backwards. So plaintiffs have talked a lot about the question of status quo. There's a couple things there. So first, on the question of Inkster schools, that is a fundamentally distinct scenario, both as a matter of fact and as a matter of law. If you look at Section 12, that is a fundamentally different section. It's got different definitions. Section 12B is the part of the revised school code that was really written in to give unique treatment to Detroit public schools and this overlay of the new district over the old one. So Inkster schools is really not illustrative, nor is it in any kind of like status quo or common understanding. In fact, the communications, and I think plaintiffs attached a lot of those communications to the complaint. The communications that have gone back and forth between Treasury and DPS over the course of several months are very clear that no one had this, well, plaintiffs had this understanding, but it was not a mutual understanding between the parties. In fact, Treasury was doing everything it could to say, well, no, this is fundamentally different. And I would go a step further, Your Honor, even if what they're saying is true, that Section 12 and 12B are identical, and we know that this is not true again because 12B was unique to DPS. But even if we go with that argument for a second, just because Treasury has, and you kind of captured this with the government estoppel notion, just because Treasury has treated another situation a certain way. Let's say that Treasury got it completely wrong. Let's say that they got it completely wrong under the law. They're not bound to do it again. In fact,
Forevermore to get it wrong
correct.
over and over and over again.
Right, and in fact, it would be Treasury's Treasury's obligation, and right, they would be obliged to in fact get it right the next time, even if that meant treating a different school district differently.
Well, do you concede that in the Inkster case, they were allowed to continue to collect an operating tax after they paid off the balance on an emergency loan?
Your Honor, that's my understanding, but I think that again ignores several things that are distinctive, right? I mean,
Right, I'm not suggesting that you can't distinguish the
Yeah,
Inkster situation.
yeah.
I'm just trying to understand whether this is an apples to apples comparison or an apples to oranges comparison.
it's an apples to oranges comparison, Your Honor, and even if it weren't, Treasury's not obligated to continue with the same interpretation of the law, even though we're talking about different laws here. The second thing I want to talk about, this question of status quo. If we're talking about status quo, again, in the vein of this partnership that the state has with DPS, Treasury wrote up a brand new debt service schedule that said, you know, instead of paying this emergency loan off immediately, we're not requiring you to do that. You can make interest payments, right? These 27
Interest-only payments?
interest-only payments, $27,000 up through September of 2026.
Okay, so that feeds into your argument about irreparable harm, because as long as they make interest-only payments, they can continue to collect this operating tax.
They absolutely can, Your Honor. And again, we're partners and we're trying to be flexible.
I understand.
And insofar as they are insisting on paying this off now,
Right.
to the extent that there is a harm, and Your Honors, the state is not conceding that there's any harm here,
Sure.
so I'm going to use the phrase purported harm.
Right.
To the extent that there's any purported harm, it is a harm that they are inviting upon themselves. They are electing into it.
Help me understand this. So let's say that they choose to make interest-only payments through 2026, whenever the drop dead date is. The revenue stream is obviously far greater from the operating tax than the interest-only payments. They can then dedicate all the rest of that revenue stream to paying these legacy debts.
Your Honor, it's not clear that that's what would happen. In fact, the legal position that we're taking, and I'll get to that in a moment,
Okay.
is that the operating obligations, right, or the operating levy is dedicated to operating obligations. So
Right.
I don't think that they can take the amount that they're otherwise collecting out of the 18 mil, the operating levy, and send it to other legacy debts. I don't think that's
Okay,
what.
well, and I appreciate your candor on
Yeah.
that, because if you had said that you take the position they can, then I think the whole argument for irreparable harm in 2025 just evaporates.
Your Honor, that may or may not be the case. I think that the notion of irreparable harm evaporates just based on the fact that they are the ones disturbed. I mean, they're talking about Inkster as the status quo. But in terms of this current situation, the status quo is the payments that they are making based on this indenture agreement, based on this loan note. The status quo is make the interest payments. And in the meantime, monies are appropriated through 2025. I have no reason to believe the legislature wouldn't make an additional appropriation to cover 2026 as well. They would continue with their operating levy. They would continue getting the foundation, not only allowance, but the backfill.
I see. So your argument isn't so much that they could redirect the revenue stream. Your argument is simply if they make interest-only payments, they're held harmless on the foundation grant.
Correct. The foundation grant will stay in place through.
I see your argument.
Yeah, so-
I overread it. Now I understand
Yeah,
exactly what
so
you're saying.
the money at issue, well, first of all, we know that, I mean, he's saying, my brother counsel's saying the notion that that they can't recoup this money. Your Honor, we know that that's not irreparable harm. Just as a matter of law, when we're talking about irreparable harm, you're talking about someone, you know, the closest case that we got to this question, Your Honor, is someone who needs a.
Because I'm not sure I agree with you on that. The idea that money is fungible and a loss of money can't be irreparable harm rests upon the proposition that on the back end, you can recover the money, and money's fungible, and there are always money damages that can make up for whatever you lose in the short term. If they can't get this money back, and I presume by seeking declaratory relief, they can't get this money back.
Your Honor, well, so first, I think that ignores a few things. It ignores the question of this revised debt service schedule. It ignores that completely.
I got it.
It also ignores, Your Honor, I didn't hear Brother Counsel say anything about the school revolving loan fund program. It's the SLRF SLURF debt program.
Saw that.
The representation was made that there's limited revenue streams. One of the core revenue streams that was completely omitted is the SLURF program. So in that program, if you have capital expenditures that you've bonded, so you've got that 13 mil debt millage, and you have certain capital expenditures, and the debt millage is not sufficient to pay those, that's what the SLURF program is
Oh,
for.
it picks up the shortfall.
It picks up the shortfall, Your Honor. So the state is effectively a guarantor on that debt millage.
Right,
So
I
this
got it.
notion
I
that
understand.
they're going to fall short on the 13 mils, and this is going to be something that they can't recoup, and it's irreparable. Again, it ignores the interest payment debt service. It also ignores the entire SLURF program, which they're a part of.
I got it.
And I just want to wind that in very quickly to this question about the full faith and credit. Certainly a school who's not part of the SLURF program, if they had general funds laying around that they wanted to dedicate to capital debts or other debts.
Just debt retirement generally.
Yeah, I mean, I'm not sure that there's anything that would preclude them from doing so, but most school districts, if not all of them, both as just a prudential matter, but also as a legal matter, most, if not all of them, are part of the SLURF program. It's a great program for local districts to be able to basically get the state guarantee on their bonded debt to get better interest rates as a result. And DPS is a part of this program too. So it's not clear to me why the representation is being made to you that, that these revenue streams are limited and this money can't be recouped. There's all kinds of state resources that are available to them now to make sure that these monies are in place and that they can continue operating both as with respect to the obligations of the old district, but also the ongoing. Because really what we're talking about, Your Honor, I don't want to lose sight of this fact. We're talking about the education of kids. That's what really matters here. And the state is there, and we're going to continue to be there. We're a continuing partner. So that's there. And to the extent that the status quo is being disturbed, it would be disturbed by insisting on making the remainder of this payment, placing yourself voluntarily on this ledge, this precipice, and, and then blaming the state for not grabbing you and pulling you back. That's effectively what's happening here. So I guess that's what we want to say about the irreparable harm. And then to the extent that they say there's no operational deficits, Your Honor picked this up. If the old district can't levy the operating millage, the new district is the one that's doing it. So they have an operating levy. There's no operational deficits in that case.
But just to be clear about that, I think you would concede that if the new district goes to the voters, gets approval, and starts collecting an operating tax, the revenue from that operating tax cannot be used to retire the legacy debt of the old DPS, right?
That's absolutely correct, Your Honor. And that was a remarkable exchange that you had with Brother Counsel. You noted that this would be contrary to what the voters thought, right?
Sure.
Your Honor, that's true as a matter of law. The operating millage is used for operating obligations. And whether it's the new district or for the old district, that's a question of law. That's a categorical proposition. So the notion that the voters wouldn't have contemplated this for the new district, but they completely contemplated it from the old district. Your Honor, I think that violates common sense and violates the plain definitions that we have in the statute at issue.
That certainly would be how I would suss it out if I had to just think about it. And if the statute makes that an ironclad guarantee, all the better.
Your Honor, and you made the note, wouldn't it be anomalous to use an operating levy to I guess to cover non-operating purposes? So the plaintiffs have this very, very broad proposition. They put it in their brief, and I heard Brother Counsel indicate something along these same lines this morning. all school district debt is effectively for operating purposes, operating obligations. Your Honor, operating obligations, and I'll credit Brother Counsel for noting this, it has its own distinct definition. It is distinct from capital debts. There are,
Sure. For what it's worth, I happen to know more about this than I should because my wife was a teacher for 30 years. And then when she retired, she was on the school board for 2 terms. And so just, the idea that you could use revenue from an operating tax to retire debt just seems, I think that would make her head explode.
Your Honor, and there's a reason, it makes our heads explode too. There's a reason for that. It's because these are separate millages based on separate millage authorizations.
Right.
Paid by separate voting bases. Would you, I mean, they're not paid by the same voting
Right.
basis. If you have one voting base that's responsible for one thing,
Right. Yep.
would they be surprised to know that the money that they're paying towards what they thought was for purpose A is actually being used for purpose B?
Exactly.
The revised school code, in conjunction with the Trust Fund Act and the school aid fund, give distinct treatment to each of these for those reasons, Your Honor. So they mentioned the definition in 12B, 15B. That is a narrow definition of operating obligation.
Yep.
And and I'm not going to read the definition to
Sure,
you,
sure.
Your
I
Honor,
mean,
but
I have it, before I even came out here, I had it highlighted and circled in red.
Yeah,
and
I
all
mean,
sorts of things.
the short story on it, Your Honor, is that it explicitly excludes, right, other forms of capital debt. It's really for operating purposes. And the new district is the operating district.
Yeah.
They're the ones actually educating kids.
Right, the DPS does nothing today except service the legacy debt.
Correct, correct. So you have the new district, which as of right now is not levying the operating millage, and we're not requiring that they do so. It wouldn't be until they retire all operating obligations, of which, right, you had this waterfall, you had a number of obligations that were part of that operating It was vendors, right? It was legacy retiree debt.
Sure,
And then it was also this $150 million loan.
Right, right.
So you have this narrower definition of operating obligations. And why does that matter? And opposing counsel noted this. It's because that's what triggers the treasurer to notify new district operating obligations have been satisfied. At that point, new district still levies the 13 mil, but the 18 mil goes to the new district, right? The thing that Brother Counsel did not point out to you is the dissolution provision. So if you look back at the revised school code, and again, Your Honor, I know that you've read all this stuff, so I will
No,
not.
it's fine.
The RSC provides that once so to that question of what is debt, they're making this categorical claim about all debt, and debt means all debt.
Right.
Your Honor, there's a reason for that. It's because the second notice under 12B, the second notice goes to when all debt is repaid. And what happens when all debt is repaid? DPS is dissolved.
Yeah, right.
It's a dissolution.
Right, yep.
So
Yep.
it's a two-step. So first you have notice about the operating obligations being retired. That's what triggers, okay, new district, now you are authorized to levy for the 18 mils.
Yeah.
But in the meantime, I'm sorry, Your Honor. go
I
ahead.
guess that makes sense too, because I was a little bit perplexed by the language in 3C, doing all other things relative to the dissolution of the qualifying school district, which seems to suggest that A and B are 2 specific examples of trying to move toward the dissolution of the qualifying school district, and then C is kind of a catch-all.
I think that's correct, Your Honor. And this, so the notion that we're talking about all debt here is
Right.
you're taking all the stages in the process, right?
Yep.
And you're amalgamating them into one giant monolith,
Yep.
and you're giving them all the same treatment, despite that the fact that we have distinct definitions, distinct voting bases. So, Your Honor, that's a real, I think that's maybe the core problem with the representations and their assertions is that they're ignoring all of these much finer distinctions.
You've answered everything that I wanted to ask you. So if you have other things you want to say, I promise I'll just sit and listen for a while.
Well, Your Honor, as a matter of principle and practice, I certainly try in the very first instance to be responsive to I want to know what's bothering
Oh,
you, Your
yeah.
Honor.
No, and you've done a great job. Both of you have done a great job of answering my questions.
But I do want to make sure I look over my notes and make sure that I've kind of captured everything.
Take your time.
I guess I want to note very quickly, and we've covered it, so I don't think this is one of those things that's bothering you, Your Honor, at this point, but just for the record, I would note this. One of the key distinctions with Inkster, I mean, here we're talking about $357 million in SLRF debt. Inkster's was 1 million. Fundamentally distinct scenarios, again, under different provisions of the revised school code.
Yeah, I don't think you have to worry about me saying that your clients did something in the Inkster situation and therefore they're forever more bound to do the same thing in every other situation that's analogous.
So the other thing I guess I would note, Your Honor, is that the capital debt that's financed via the debt millage, that's used for facilities. Again, we're talking about educating kids here. It's used for facilities where the kids go to school. Those facilities are being operated by the new district. So the 13 mills is in fact still going to the question of, right, so the question I guess becomes why would you have these two things going on at once? Why would the new district get the benefit of having things paid off early? I mean, they're getting the benefit of the actual buildings, the facilities, right? Why would we do it this way, Your Honor? That's not clear. And I guess to address the last, and we kind of hinted at this already, but to address the last two prongs of the analysis.
Balance of harms and public interest.
Correct. Your Honor, we already talked a little bit about the fourth one, right? We have a responsibility to approximately 900 other school districts. And as well as 10+ million citizens across the state, that money could be used for any, it's not restricted. These would otherwise be general funds. We would look to dedicate it as much as we can to education, but there's any number of other purposes that we could put this money to. Detroit Public Schools is very, very important to us. We're partners. We understand the situation that we're in. The state worked with the legislature to try to put something together to make operations possible, right? And to give their kids the best shot at the best education they could get. We're mindful of that. But we do have an obligation to the rest of this. They're one school district, an important one. And it's not that we don't care. We care very much. The question of the balance of harms, Your Honor, they're representing to you that there's about $328 million in interest payments.
Sure, that they could save.
That they could
take
save.
this revenue stream and apply it to legacy debt.
So for them, what this really boils down to is interest savings. Your Honor, the amount at stake per their own, and I'm just, again, this is a C8. Well, this
It's not even C8.
This here is not a
It's
C8
before
disposition.
C8.
Correct, but we do have a C8 motion pending, so we are trying to keep our representations limited, at least as it concerns that motion. Per their own pleading, they've got the schedule attached as Exhibit 1 to their complaint. Their own analysis puts our obligation right around $705 million through 2030.
I saw that.
And the representation being made to you this morning is actually the status quo would run to 2033. So what do the remaining 3 years look like? Our estimation is it's roughly 100 million. So really the 705 million that they've represented in attachment 1 to their brief, if we take that and we expand the logic out to 2033, which is what is being represented to you, we're really looking at $1+ billion roughly, which is what the state is on the hook for.
Yep.
$1+ billion. So 328 million in interest savings, and I'm not minimizing that. Your Honor, I'm not. we understand the position that
Sure.
that Detroit
Sure.
Schools has been in, and we
Sure.
understand why the legislature did what it did. And and again, we're partners.
Right.
We're partners in the SLURF program.
Mhm.
We're partners in the foundational allowance. But we have this apparently $1+ billion that we need to make sure we're responsive, right? To the, I mean, Detroit Public Schools is important, but there are
I got it.
other school districts
understand.
and other public purposes that we need to consider.
Indeed.
Your Honor, if you don't have any further questions, I would like the opportunity to address the conversation that you have next with opposing counsel.
Oh, sure, of course.
But I
Yeah.
greatly, as always, appreciate Your Honor's inquisitiveness and your time.
Oh, no, thank you so much, Mr. Thompson. I would never deprive anybody of a second round. I want to make sure that every issue that's important to both of you gets aired.
Thank you very much, Your Honor.
Thank you, Mr. Thompson. Appreciate it. Mr. Eldridge, welcome back. If you could limit this to maybe 10 minutes tops, that'd be great. But take the time you need.
Can do. Thank you, Your Honor. And I do appreciate council's comments about wanting to work
Sure.
with the district.
Sure.
And we certainly would love the opportunity to continue talking about this matter. But I don't want to lose sight of the fact that, yes, it's one school district, but it is by far the largest school district in the
No
state of
question
Michigan,
about
right?
it.
You know,
Look,
we all know
the
that.
entire state has a vested interest in the Detroit public school system being successful.
Correct.
No doubt about it.
So I want to just address, I've got 5 things written down that I want, well, 4 things written down that I want to
Sure.
address briefly.
Sure, please.
Based on council's comments and questions from you. What, you had ended kind of your line of questioning with me about this, idea of are we using money to actually pay off, things going into school operations.
Mhm.
And I don't want to forget the bonded debt was incurred to pay for school operations.
Absolutely.
Right? That was for
Correct.
equipment, it was for
Right.
facilities, it was for energy conservation efforts and savings. I mean, it was incurred for the purposes of maintaining school operations. So I don't want to lose sight of it. Council, and you had talked, Your Honor, about the schedule of the payments. Let's just slow it down.
Oh, you're talking about the interest-only payments through
Correct.
sometime near the end of 2026.
Correct. So which would just,
It keeps the foundation allowance money flowing, no doubt about that, right?
it would, but here's the problem. This is the schedule of repaying the emergency loan is entirely within the control of the treasurer.
But they can't call the loan tomorrow, can they?
They set the schedule that we're currently paying now, back in 2021. They set the schedule back in 2021 that is getting us to the point of repaying it sooner.
But
It's in the master agreement that we mentioned in our briefing, and we attached, or I don't know if we attached it, but we certainly mentioned it's a master agreement between the DPS and the treasurer, and it says plain as day in there, they have the ability to control and authority to control that schedule. So they set the schedule. They could slow it down if they wanted to. They could slow the payments down if they wanted to.
right.
They have not, and here's why.
But help me understand this, because it's one thing to say that whatever is the operating agreement remains the operating agreement unless you both agree to change it, as most contracts say. So if they've now given you a schedule that allows you to make interest-only payments till the end of 2026, it seems to me it makes a big difference whether they can just unilaterally change that and say, never mind, now you've got to pay it by the end of
Well,
2025.
that's what the master agreement says.
Right,
They
so
do
your
have-
view is they could do that.
They do have that
They could pull the
authority.
rug out from under.
I don't know that they would, but they do have that
Right, I
authority.
understand.
Right? But here's the problem, and this is what sparked really this issue, why we're here, is that issue came up. Well, let's just slow down the payments or make interest-only payments. The problem is we're continuing to collect operating tax revenue at a significant rate because the property values have gone up. That means there's going to be money left over if we slow down payments and there's going to be a surplus at the end of paying off the debt. If we do interest-only payments, we're never paying off the debt. We have an obligation to
Right,
pay
of
off the
course,
debt.
right, of course.
Right? But at some point, we're still collecting all the operating revenue.
Right.
And the operating tax revenue, that is. If we slow down the payments so that we're not making bigger payments now, right? We're still going to be having a surplus. The question came up, what can we do with that surplus?
Right.
And the answer was, you can't use it to pay off the legacy debt.
Right.
And what happens to the surplus? We can't give it to the new district. What happens to it? There's no answer to that question. So what was clear, though, is that we were told we cannot,
Right. It's a matter of law. You
Right, we
cannot
cannot-
apply it to legacy debt.
well, that's what they're saying.
Right. No, I understand
Right,
there.
right. So that doesn't, the slowing down the schedule doesn't cure the problem.
It just creates a pool of funds that nobody even knows what to do with.
Correct. So that's not a solution. And I think everyone wants to get this emergency loan paid.
Sure.
Paid off and paid off as quickly as possible. Another point, Your Honor, council made a reference to the SLRF loan or the revolving fund being a source of revenue. That's not a source of revenue. That's a loan. That's incurring more
Right.
debt
Yep.
from the state that then is going to have interest payments on it. And then we're going to have to, that's just not a solution either.
Right.
To say,
And
let's
then
just
it's-
keep incurring
right,
debt.
It's the difference between farm loans and farm subsidies.
And then we never get to dissolution.
Right.
If we're continuously just relying on this revolving
Right.
fund.
No, I understand that problem completely.
So that's not a realistic solution to just say, let's just keep doing that. And then last, I just want to point, well, two last points. The voters approved the operating tax in Detroit, the same voters that would be asked in the new
Sure.
district, in 2020 and again in 2024, long after the new district was created. So, and I think everyone was fully aware what that operating tax was going to be used for, including to pay off debt. I don't think there's any question about that. So I just wanted to make that point. And then last, I want the court to understand that we're not asking you to say Inkster happened the way Inkster happened, therefore this happened. We raise it simply because they're just doing it about face in terms of how they're interpreting almost virtually identical statutory language. And that section 12 definition of debt includes that reference to the municipal finance
Right.
act.
Section 12 governs Inkster, section 12B governs your clients, but
They're very similar.
right, the terminology is
Right.
the same in the definitions.
Except in 12B for DPS, the legislature expanded that definition of debt even farther to make it even broader. So with that, Your Honor, I have nothing else, but happy to answer any other
No,
questions.
thank you, Mr.
Appreciate your
Aldrich.
time.
You've done a terrific job. Thank you so much. Mr. Thompson. The final word.
Your Honor, I appreciate Brother Counsel's brevity, and I will try to be similarly brief. So on the question of the surplus, right? I don't know that these items are in evidence before you, Your Honor, but I do think it's worth noting. There is an indenture agreement. I have not gotten through their motion for summary disposition yet, so it's not, I couldn't tell you right now whether or not it's part of their motion.
Right.
However, that indenture agreement deals with this question of the surplus. So, and I'm just going to note it now, Your Honor, for the record, if I may.
Oh, you may. This is
Okay.
a $64,000 question
Okay.
at the moment.
Your Honor, section 313 of the indenture agreement says upon payment in full of all obligations as evidenced by written certification by the state treasurer, any amounts remaining in any fund or account shall be remitted to or for the benefit of Detroit Public Schools Community District in accordance with state law pursuant to direction in such certification. And I'll note for the record, Detroit Public Schools Community District is the technical term for what we've otherwise been referring to as new district.
Right. And I did catch that. So in essence, what you're saying is if they are able to build up a pool of excess funds and pay off the $150 million emergency loan, the excess funds would then go to the new
It
district.
goes to the new district, Your Honor, in accordance with the indenture agreement. So this question of the disposition of that funds is not
Okay. I
It's
got
not
it.
a
All right,
question.
so you still stand by your position that as a matter of law, it can't go to pay the other legacy debts.
Correct.
And now you filled in the other piece of that by saying, and here's where it would go.
That's correct. It would go to the new district, which is the operating district,
Right,
the
got it.
ones actually teaching
Got it.
and learning, right? The question of, he says that the SLRF loan would incur more debt. Your Honor, that's true. However, that is this, when we're talking about status quo, that is the status quo. The SLRF program is used by school districts around the state.
Sure.
the majority, if not most, maybe, Your Honor, I couldn't represent to you all of them, but I could certainly stand here and represent to you most of them. That is the status quo. That's how these things work with respect to the debt millage, the 13 mills. That is the nature of the partnership between the state and the school district. That is the status quo. Your Honor, I don't know that I'm going to belabor the Inkster thing, other than to say this, that it's being said that there is an about face. It's not an about face. They're distinct. The virtually identical language, why do you need an adverb? Why do you need virtually? I don't like adverbs, Your Honor. Whenever I hear them, my ears prick up. And maybe you're like me, that the reason you use an adverb in that instance is because they're not identical. And with that, Your Honor, if you have any further questions.
No, I don't, Mr. Thompson. Thank you very much. I will tell both of you that this has been extraordinarily illuminating, very, very helpful. Any judge who wants to decide everything without oral argument, I think is not only missing out on a fun opportunity to hear terrific lawyers argue, but also is missing the opportunity to pick up on all the nuance in the arguments. And I think that was readily apparent today. So thank you both very much.
Well, and if you'll allow me, Your Honor, if I may, just very quickly for the record, I want to say thank you for this hearing. Thank you for your inquisitiveness. Thank you to opposing counsel. I think that their briefing and their arguments have definitely helped to sharpen this issue.
Absolutely.
Again, we want to have a partnership and we think that they're helping us out in that respect. I just want to say that for the record.
Okay, thank you. And you will get a decision within the next week. I promise you. I recognize that there's a deadline. I understand the need for it and I will comply. Okay? Thank you so much. All right, very good. Thank you to the court reporter. We can go off the record now.
All right, thank you.
Thanks so much. Okay, thanks, everybody. Really appreciate it. All right, thank you, Dan. Wow. I warned you before I came out here. This wasn't,